Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
Welcome back into the Outlaw Lawyers. Josh Whitaker and Joe Hamer, managing partners, Whitaker and Hamer Law Firm, hosts of the program, practicing attorneys here in North Carolina. Joining us on the program today from the Morehead City office, Cassandra Nicholas, also an attorney at Whitaker and Hamer, and Taylor Scruggs-Smith, an attorney with Whitaker and Hamer. Offices located conveniently, Raleigh, Garner, Clayton, Goldsboro, Fuquay, Varina, Gastonia, and Morehead City. We'll tell you more about how you can get in touch with Whitaker and Hamer if you have a legal situation. But Josh, first and foremost, we're going to talk some probate.
We are. We get a lot of questions about, someone's already passed away, and we have relatives, we have family, spouses coming in, asking if a will needs to be probated. Does an estate need to be administered? A full estate, something less than a full estate? How do they distribute, property? Just tons of questions once someone's gone. And so we got some questions that we're gonna ask about that. But before we do that, I have asked Chat GPT to write more haikus. So I had Chat GPT write a haiku about attorney Taylor Smith Scruggs. Taylor, do you want to hear this haiku?
Sure.
All right. So
of course she does.
Yeah. So this haiku is by Chat GPT, our chatbot, about attorney Taylor Smith Scruggs. So here we go. A skilled legal mind, Smith Scruggs fights for justice. Clients well aligned. I thought that was good.
You should frame that in my office.
I haven't read one of these. You weren't here last week, but Joe did one about me and did one about him. But we feel like that should go on our bio, right? Like our bio on our firm website, So Cassandra, I had it write one about you too. You want to hear yours?
Sure.
All right. With knowledge and poise, Nicholson advocates well. Legal wins in sight. Which, again, I think is a very good haiku.
When you find out your boss doesn't know any of your last names.
Right. I wonder if anybody else was going to catch that.
All right. Well, what did I do wrong?
You said my name backwards.
Oh, yeah,
and mine is Nicholas.
And she's not Nicholson.
Look, I think we could have held that in until we got done.
No, it's pure bloopers.
Well, you know what I meant.
Nicholson, here's Johnny.
All right. Joking
but
aside.
Not bad for hiking.
Not bad at all.
I'm not good with names. I've made that disclaimer several times. If I can screw up a name, I'm going to screw up a name.
We might both be in trouble after the show, Cassandra.
All right, probate administration law. Cassandra, I know you get a heavy helping of these because we handle these all across the state. This is something that we handle from mountains to the coast. We help North Carolinians with estate administration, and the first step I find for a lot of people, hopefully the deceased, right? Hopefully the deceased person has made an estate plan. And so a lot of times, my first bit of advice is, hey, is there a will, right? Cassandra, you probably, a lot of times they'll come in with it, but sometimes they don't know.
Yeah, absolutely. So then it's important to look in all of the usual places for the will, including and especially, the lock boxes at the bank. What are those called?
I think that's
those
safety deposit box.
Yeah.
Safety deposit. That's the word I was looking for. And there's a particular procedure for actually inventorying what's in those with someone like supervising you from the court. So finding out how to do those things right away is important after someone passes.
Well, Cassandra, let me ask you this. So I know we get a lot of questions, and especially from everybody, even if I'm just at an event, do you even have to do an estate administration through the courts?
So that will depend. Really, the best estate planning does allow folks to avoid having to do the estate administration process through the courts at all, where all of their assets transfer as a function of law or operation to someone else. Having someone else on title to your property, titles to your vehicles, as pay on death beneficiaries for your bank accounts and your retirement accounts. If those all automatically transfer, you get to skip all of the court steps. You're done.
So usually when I sit down with folks on the opposite side, right? So we also do estate planning. And so we help a lot of people, obviously before death, kind of plan for their death and what's going to happen. And we get involved in trust and wills and power of attorneys and all this other stuff. But if you do your estate plan, it's very important for you to tell the people who are going to be executing your estate plan after you're gone, whether that's a surviving spouse, a child, a professional, an attorney, a CPA. You need to tell people that you have a will and where it is so they can get to it when you're gone. I know we serve as executor for a lot of folks who maybe don't have any close family in the area. And then maybe they live alone. And so I know when I'm doing that, I know where their will is. Sometimes I have it. Sometimes I know where it is in their house. But that's the first thing. If you go through the trouble, which everybody should do, it's not that much trouble. It's very easy. But if you get your estate plan done, the people who are going to execute that plan need to know it and need to know where the original docs is. A copy of a will is not worth a whole lot in North Carolina. The original will is what's important. And I see I don't have one. A lot of people don't have safety deposit boxes anymore. It used to be very common. Some counties, you used to go register your will downtown. So the original was at the courthouse, and that's kind of fallen out of favor. Most people don't do that anymore.
Didn't they used to give out safety deposit boxes when you got new bank accounts or something? I know that's how my grandma got 5.
Maybe back before my day, they did that. No one has ever offered me a free safety deposit box.
It is still an option to go register your will, file your will while you're still living with the clerk of court in the county where you live. It just gets a little bit complicated if you do end up moving during your lifetime, or if your executor that you've named doesn't know that's where it is.
We had some clients who brought up a good question. We had some clients who moved here from a different country, and so they were here and they had their minor children, and they wanted to know if they're they were planning to keep the NC state statute talks about keeping your will with your other important papers wherever that may be. So it could be a desk drawer, right? It could be anywhere. It could be in your house. You could have a vault in your house, or what do they call that, a safe, a firebox, or whatever it is. But anyway, wherever you put it, they were concerned what if the house burns down? The will's destroyed. We're both gone. All of our folks are on another continent. How does someone know what to do? Know that you are our attorney. Know where the will may be. And those are all good questions. I was like, you need to tell them, right? You need to let them know what to do in case something happens to the both of you. So, and then we also, a lot of times I'll give folks a little cheat sheet, right? So if you're doing your estate plan and you're updating it every year, kind of keeping a list, a lot of people don't get statements like back in the day. That's how we figured out, right? If someone passed away and you were trying to figure out who they owed or who to give notice to, you'd wait for their car statement to show up, their mortgage statement to show up, credit card statements. But a lot of people don't get statements mailed to them anymore.
Electronic.
Yeah. So we've got this little guide that you kind of give people an idea. Hey, look, this is where I bank, but I also have an account here. Here's my financial services person. And so, your spouse, if your spouse survives you, is probably going to know that. Your kids may not know that, right? Definitely somebody further removed than your kids may not know. So when you're gone, you can't tell them. So it's good to tell them folks that while you're still here.
So Cassandra, though, if the will's probated, does that if there is a will and there's still property that has to be transferred, I know there's kind of a few different types of estates. Which one do you do?
So if an estate does need to be opened, whether there's a will or not, there's also procedures for opening an estate if there's not a will. If you die without a will, it's called intestate. But there are different types. So there's a small estate, and that's for assets up to $20,000, or if your only surviving heir is your spouse, up to $30,000. And if it's assets above that, then you're doing a full estate. Interestingly, in North Carolina, those assets that are part of the estate do not include real estate.
Yes, right.
And
Go ahead. Sorry.
They also don't include anything that is transferring automatically. So any of the bank accounts and vehicles or anything that are automatically transferring, you don't have to count towards that limit either.
Yeah, in North Carolina, real property, so land, real estate, it technically passes automatically when someone passes away. which is crazy because we don't automatically know who it's going to go to, right? So let's say something happens to me. Let's say I got a will that leaves everything to my wife. So as soon as I die, the legal fiction is that title vests in my wife right away. But you wouldn't know that, right? Me and my wife know that, but Taylor may not know that. Cassandra, third parties aren't going to know that. So you have to go probate the will. And even though the real property may not be listed as an asset of the estate because it's already passed outside of probate, you still have to probate your will to prove to everyone that she is the new owner of the property. A probated will is a lot like a deed. It's something that third parties can look at to determine who owns property, right? So we do a lot of title. So I've got a title search now where someone died out of state. We don't have an estate. He had several kids. Only one of the kids is selling the property, but we don't know how we got to this one kid. It's he may know, right? He may know exactly why it's his property, but we don't have anything on the public record. There's no deed. There's no open estate. So, clerks, I would say when you're down at the courthouse, if you haven't consulted with an attorney and there's real property in the estate, real property that's going to be sold or mortgaged within the next 2 years after the death of the deceased, the person who passed away, you need to talk to an attorney because there's some tricks of the trade there.
Definitely, because it's not required that you open an estate for that purpose under state law. But if you're trying to sell the property, a closing attorney or a title insurance company is not going to let you do that unless you've proven who the legal heirs are. And typically they require an estate to be open to prove that. So sometimes that's the only purpose of doing estate administration is to legally prove who the heirs are so that you can sell a property.
Right. And then there's laws and rules about giving notice to potential creditors to cut off creditor claims. And so that may be something you need to talk to an attorney about because sometimes it's the best thing to do and sometimes maybe it's not the best thing to do. But there's all kinds of, tricks, not really tricks. It's just laws and knowing what side of the law you need to be on. And so a lot of stuff can happen there. But it's a process, right, Cassandra? I mean, this is not going to, if you got to open up a full estate or, it's not going to be a week-long process more than likely.
Absolutely not. So with a full estate, as you were just mentioning, the notice to creditors period, notice to creditors isn't necessarily required with a small estate, but it is required with a full estate. And the notice to creditors period is at least 90 days. From the time that the notice runs the first time in the newspaper. So the minimum amount of time this process would take you is over 3 months. Typically, it's going to take a little bit longer than that because there's some processing time involved on the clerk's end to even get the estate open. And then on the back end for them to process the additional filings that you'll be submitting. It's not a short process.
And you got to be very careful. We're coming up against a break, so I don't want to go into too much detail here, but you have to be careful. If you have estate assets, those estate assets have to be handled, documented, delivered to heirs in a certain way. And the more assets an estate has, the harder it's going to be to administer or to probate. And so just be wary of that. If you've got an estate with a lot of assets, you've got other heirs that aren't you have a fiduciary duty to handle all that the right way. And there is a right way, and every other way is wrong, right? There's things you can pay, there's things you can't pay. And you can get yourself down a pretty big rabbit hole if you don't do it the right way. It's hard to go back. You can make life a lot harder for yourself. So that's something I would definitely recommend. If you've got an estate, there's some assets in it, you want to make sure you handle it correctly, because if you don't, you're not going to find out about it for a while. And once you find out about it, you may not have a lot of time to go back and fix the issue. But before we hit break, I did have the chat bot write us a haiku about probate.
Can't wait.
All right. And this one was good too. And each one's better than the last one. I didn't put anybody's name in this one, so I don't have to worry about any problems there.
My name's Morgan Patrick.
Life's last chapter writ. Probate settles earthly ties. Inheritance done.
Oh.
I thought it was pretty fancy. I thought it was pretty good.
If you have any questions about probate, and obviously a lot of moving parts, you can always call Whitaker and Hamer, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call's about, and an attorney with Whitaker and Hamer will be in touch. You can always email your questions to the show, questions@theoutlawlawyer.com, and we will answer those on future programs. We're back right after this.